I never thought laughter could echo louder than a judge's gavel. But that morning in courtroom 4B, my wife proved me wrong. Emily Whitmore sat across from me with that same polished smile she used at charity dinners, the kind that made people believe she was always in control, always a step ahead. And when she looked at me that day, she didn't just see her husband of 8 years. She saw a man she believed she had already defeated. The courtroom smelled like polished wood and cold air conditioning, every seat filled with quiet anticipation, as if everyone knew they were about to witness something they could retell later in fragments, the kind of moment people never forget. I stood there in a simple navy suit I had worn to job interviews years ago, not because I couldn't afford better, but because I didn't see the point of pretending anymore, while Emily's lawyer leaned over to whisper something that made her smirk widen. "Your Honor," he began, "this case is straightforward. My client has carried the financial and emotional burden of this marriage for years, while Mr. Whitmore contributed very little." A few soft chuckles rolled through the room, subtle but sharp enough to land, and I could feel the shift, the quiet judgment forming before I had even spoken a word. Emily didn't even bother to hide her reaction. She tilted her head slightly toward her friend seated behind her and whispered something that made them both laugh under their breath, like I was already a story they had finished telling. But what none of them understood, what none of them had bothered to ask, was that stories are only predictable until someone decides to turn the page. I remember the early days of our marriage, when Emily and I would sit on the floor of our first apartment eating takeout, because we couldn't afford a dining table, laughing about how we would build something bigger together, how we would be unstoppable as a team. Somewhere along the way, that version of us disappeared, replaced by meetings she didn't invite me to, conversations she ended early, and a distance that grew so slowly I almost convinced myself it was normal. The first time I noticed something was wrong, it wasn't a dramatic discovery. It was small things: a phone turned face down too quickly, a name she stopped mentioning, business trips that didn't match her calendar. I asked questions, but she answered with calm precision, the kind of answers that sound complete but say nothing at all. By the time she told me she wanted a divorce, she didn't even look emotional. She looked prepared, like she had rehearsed the moment in her mind long before I was included in the script. And now here we were, in a courtroom, with her treating me like a footnote she was ready to erase. "Does the defendant wish to respond?" the judge asked, glancing in my direction with neutral patience. I could feel every eye in the room settle on me, waiting for hesitation, for frustration, for the moment I would finally break in the way they expected. Instead, I reached into my briefcase and placed a single sealed folder on the table. It wasn't thick, it wasn't dramatic, it didn't need to be. Emily noticed it immediately, her expression tightening just slightly, the first crack in her composure. "What is that?" her lawyer asked quickly, leaning forward. I didn't look at him, I looked at her. "Just something I thought the court should see," I said quietly, my voice steady in a way that didn't match the assumptions they had built about me. The judge leaned forward slightly, signaling for it to be brought over, and a court officer collected the folder, carrying it with the kind of formality that makes ordinary paper feel heavier than it is. Emily let out a small laugh, trying to reclaim control of the room, shaking her head like I had just made a harmless gesture. "Is this supposed to be your big surprise, Daniel?" she said softly, loud enough for others to hear. I didn't answer, because answering would have meant playing by the rules she thought still applied. The judge opened the folder, scanning the first page, then pausing, his expression shifting almost imperceptibly. That pause lasted only a second, but in that second, something in the room changed, the air tightening as if everyone had sensed the beginning of a turn they couldn't yet see. Emily's smile faltered just slightly, not enough for most to notice, but enough for me to know she had felt it too. The judge turned another page, then another, and the silence that followed was no longer casual. It was deliberate, heavy, and unfamiliar, the kind of silence that doesn't come before nothing, but before everything changes. The silence in the courtroom did not break. It deepened, stretching across the room like a held breath no one dared to release. I could feel Emily Whitmore's confidence beginning to shift, not collapsing, not yet, but subtly adjusting itself the way people do when they realize the ground beneath them is not as stable as they assumed. The judge continued reading, his eyes moving across the pages inside the sealed file I had submitted, and with each page turned, The atmosphere grew heavier, less like a legal proceeding and more like a moment suspended between certainty and collapse. Emily leaned slightly toward her lawyer, whispering something under her breath, but he did not respond with the same confidence he had carried earlier. Instead, his posture changed, shoulders tightening, eyes narrowing as if trying to interpret something that was not immediately visible. I stood still, hands resting calmly on the edge of the table, not because I felt no emotion, but because I had already made peace with everything that was about to be revealed. Months earlier, I would have been the man sitting in that chair trying to explain myself over raised voices and emotional assumptions. But that version of me no longer existed. The man standing here now had learned that truth does not need volume. It only needs timing. The judge finally looked up, his expression no longer neutral. It was measured, serious, and slightly incredulous, the expression of someone who had seen many cases but still occasionally encountered ones that demanded a second look. "Mr. Whitmore," he said slowly, "where did you obtain this documentation?" I met his gaze without hesitation. "Through legal channels, Your Honor," I replied, my voice steady and controlled. Emily let out a short, dismissive laugh, but it was no longer convincing. It sounded forced, like an instinct she had not yet learned to suppress. "This is ridiculous," she said quickly, turning to the judge. "He is trying to distract from the facts of this case." But the judge did not respond to her immediately. Instead, he flipped another page, then another, and the sound of paper in that room became louder than anything else. I could see it now, the subtle unraveling of certainty in real time. It was not dramatic, it was not explosive, it was methodical, like a structure being inspected one beam at a time until the weakness could no longer be ignored. The judge leaned back slightly, then forward again, as if confirming what he was reading against his own understanding of the case. "Counsel," he said, addressing Emily's lawyer, "were you aware of these financial disclosures?" There was a pause before the lawyer answered, and that pause was all I needed to understand that control had already begun to shift. "We have not reviewed those specific documents," he admitted carefully, and that single sentence changed everything. Emily's expression tightened, her confidence cracking just enough for the first time that day to reveal something closer to uncertainty. She turned toward me, her eyes sharp, searching, as if trying to understand when exactly the situation had stopped belonging to her. I did not respond, because responding would have given her the illusion that she still had influence over what was happening. Instead, I let the file speak. The judge continued reading silently, his expression growing more serious with every passing second, and I could hear faint movement in the courtroom, the subtle shifting of bodies, the quiet adjustments of people who sensed they were no longer watching a standard divorce proceeding. Something had changed, and everyone felt it even if they did not yet understand it. Emily finally leaned forward, her voice lower now, less performative, more uncertain. "What is in that file?" she asked, not to the judge, but to me. For the first time since the hearing began, her tone did not carry confidence. It carried something else, something closer to doubt. I looked at her calmly, the same way I had looked at every version of this moment in my mind long before it ever arrived. "The truth," I said simply, and in that instant, I saw the first real fracture in the story she had built. The judge closed the file slightly, then opened it again, as if verifying the gravity of what he was seeing. "We are going to take a short recess," he announced, his voice firm now, no longer neutral. And just like that, the courtroom that had been filled with quiet laughter and assumed conclusions moments earlier was transformed into something else entirely, something uncertain, something recalibrating, something where every assumption was suddenly under review. I remained seated as the judge called for a recess, not moving as the room began to shift into controlled chaos masked as procedure. People stood slowly, chairs scraping against the polished floor, voices lowering into clusters of speculation that tried to stay respectful but could not fully hide their curiosity. Emily Whitmore did not leave immediately. She stayed frozen for a moment, staring at me as if she was trying to locate the version of reality where this was still under her control. Her lawyer leaned in quickly, speaking in urgent whispers, but she barely reacted, her eyes locked on the sealed file that had just altered the direction of everything she thought she had secured. I did not return her stare. I simply gathered my documents with calm precision, as if nothing extraordinary had happened, because in my mind, the extraordinary part had already taken place long before we ever entered this courtroom. It was not the judge opening the file that changed things. It was the fact that the truth had finally been placed in a space where it could no longer be ignored. As I stepped out into the hallway, the air felt different, less compressed, like the building itself had exhaled. I stood near a window overlooking the courthouse courtyard, watching people move between conversations that all carried the same invisible question. What did that file contain? Emily appeared a minute later, followed closely by her lawyer. Her composure had shifted now, not shattered, but visibly strained, like a carefully maintained structure exposed to pressure it was not designed to handle. "Daniel," she said, her voice lower than before, less performative, more controlled. I turned to face her, still calm. "If you are trying to embarrass me, you are making a mistake," she continued, but the words lacked the certainty she used to carry effortlessly. I nodded slightly, acknowledging her words without accepting their premise. "I am not trying to embarrass anyone," I said. "I am letting the evidence speak for itself." Her lawyer stepped forward, attempting to regain procedural control. "We will be filing an immediate motion to challenge the admissibility of whatever was submitted," he said quickly, but even he did not sound fully convinced. There is a difference between strategy and damage control, and in that moment, everyone understood which one they were practicing. Emily looked at me again, and for the first time since this process began, her voice lowered into something closer to uncertainty than anger. "What exactly did you put in that file?" she asked again, slower this time, as if repetition might produce a different answer. I studied her for a moment, not with resentment, but with clarity. There was a time when I would have rushed to explain myself, to justify every action, to smooth every tension before it became irreversible. That version of me would have been exhausted by now. But I had learned something through the silence that preceded this moment. Not every explanation is required when the truth is already documented. "Everything the court needs to understand the full picture," I said simply. That answer did not satisfy her, and it was not meant to. The hallway behind us filled gradually with other attorneys and court staff moving between recess instructions, but I could feel attention subtly drifting toward us, the way it always does when uncertainty becomes more interesting than routine. Emily's posture shifted slightly, her arms folding across her chest, a defensive gesture that tried to restore control through physical presence alone. "You are making this more complicated than it needs to be," she said, though her voice lacked conviction. I shook my head once slowly. "No," I replied. "I am making it complete." That word lingered between us longer than expected. Complete. Not dramatic, not emotional, just final in a way that removed ambiguity. Her lawyer glanced between us, sensing that whatever advantage they believed they held earlier had been destabilized, not destroyed yet, but no longer reliable. "We will address this when court resumes," he said, more to himself than to either of us, and then stepped aside to make a phone call. Emily remained where she was. For a brief moment, neither of us spoke, and in that silence I could see something subtle shift in her expression, not regret, not surrender, but recalibration. People often assume moments like this are loud, filled with confrontation and emotional collapse. The reality is far quieter. It is a series of internal adjustments happening in real time as certainty loses its structure. "You have been planning this," she said finally, not as an accusation, but as an observation she had just fully assembled. I did not deny it. There was no need to. "I have been documenting it," I corrected gently. Her eyes narrowed slightly, searching for leverage in the language itself. "You think this changes everything," she said. I met her gaze evenly. "It already has." The courthouse clock in the distance marked the passing of time with mechanical indifference, reminding us that whatever emotional weight this carried, the system around it continued to function without pause. Emily exhaled slowly, her attention shifting briefly toward the courtroom doors, then back to me. "You are not the person I thought you were," she said. I considered that for a moment before responding. "No," I said quietly. "I am just the person you did not pay attention to." And for the first time, she did not have an immediate reply. The hallway outside the courtroom had begun to settle into a low hum again, but nothing felt normal anymore. Even the sound of footsteps seemed slower, more deliberate, as if everyone inside the courthouse understood that something irreversible had already started. I stood near the large window at the end of the corridor, watching sunlight cut across the marble floor in long pale lines, thinking not about what was coming next, but about how quickly certainty can collapse when it is built on assumptions instead of facts. Emily Whitmore approached again, this time without her lawyer beside her. That alone was enough to signal that the dynamic had shifted in ways she could no longer fully control through procedure or representation. Her expression was tighter now, not angry, not confident, but strained by the effort of maintaining composure in a situation that refused to remain predictable. "Daniel," she said again, slower this time, as if choosing each word carefully. I turned to face her fully, keeping my posture calm, grounded, and neutral. "If your intention is to punish me, then just say it," she continued, her voice carrying a controlled edge that barely held together the emotion underneath. I shook my head slightly. "This was never about punishment," I said. "It was about clarity." She let out a short breath, almost a laugh, but it lacked any real humor. "Clarity," she repeated, as if testing the word. "You think this is clarity?" I did not respond immediately. Instead, I let the silence sit between us long enough for the weight of everything already revealed to settle. In my experience, silence often reveals more than argument ever could. "You built a version of events that worked for you," I said finally. I simply brought forward the parts that were missing. That statement landed differently than anything I had said before. Not louder, not sharper, but more final. Emily looked away briefly toward the courthouse doors, then back at me, her expression now less certain than before. For the first time, I saw hesitation in the way she held herself, a subtle recalibration rather than a confident stance. "You are acting like this is already decided," she said. "It is not." I nodded once. "No," I agreed. "It is not decided. It is being examined." That distinction mattered more than she wanted to acknowledge. The difference between control and process is often the difference between assumption and outcome. Behind her, the corridor had filled again with attorneys returning from phone calls and brief discussions, their voices low but urgent. I could sense the shift spreading outward from the courtroom itself, as if the file I had submitted was no longer just a piece of evidence, but a reference point everyone was now recalibrating around. Emily crossed her arms again, but this time it felt less like defiance and more like containment. "You really believe whatever is in that file changes how this ends?" she said. I looked at her steadily. "It does not change how it ends," I replied. "It changes how it is understood." That answer seemed to unsettle her more than anything else. She searched my face for something, maybe anger, maybe satisfaction, maybe regret, but I gave her none of those. What I gave her instead was consistency, the same calm tone I had carried through every stage of this process since the beginning. "You have been preparing for this longer than I realized," she said quietly, not as an accusation now, but as an observation she was still trying to process. I did not deny it. Preparation is not dramatic when it is done correctly. It is quiet, repetitive, and often invisible until it is complete. "And you did not notice," I said gently, not as an insult, but as a fact. That statement lingered longer than either of us expected. Emily's gaze tightened slightly, then softened in a way that suggested internal conflict rather than external reaction. For a brief moment, I saw something closer to reflection than resistance. "What happens now?" she asked finally, and for the first time, her question did not carry authority. It carried uncertainty. I glanced toward the courtroom doors, where the next phase of proceedings would soon resume. "Now," I said calmly, "the information is reviewed in full context." She exhaled slowly, looking down for a moment before lifting her gaze again. The confidence she had entered the courtroom with earlier that morning was no longer present in the same form. It had not disappeared entirely, but it had been replaced by something more fragile, something dependent on outcomes she could no longer assume. "If this goes the way you want," she said carefully, "you think that means you win." I considered the question without emotion. "This was never about winning," I said. "It was about ensuring nothing important was left out." The courthouse intercom announced the resumption of proceedings, its voice echoing faintly through the corridor. People began moving again toward the courtroom doors, their steps measured, their conversations reduced to quiet fragments. Emily remained where she was for a moment longer, then slowly straightened her posture, regaining as much composure as she could assemble in the time remaining. As she turned to walk back toward the courtroom, she paused briefly without looking at me. "I did not think you had it in you," she said softly. I did not respond immediately. When I finally did, my voice remained steady. "Most people do not pay attention until it is already there," I said. And then I followed her back inside. When we stepped back into the courtroom, the atmosphere had changed in a way that was almost imperceptible but impossible to ignore once you felt it. The same seats, the same judge, the same fluorescent lighting, yet nothing felt stable anymore. Conversations dropped into silence as people noticed we were returning, as if the room itself understood that the earlier recess had not paused the case, but transformed it. I took my seat without hesitation, placing my documents exactly where they had been before, maintaining the same calm posture I had carried since the beginning. Emily Whitmore sat across from me again, but her composure now required effort. It was no longer automatic. It was constructed. The judge entered moments later, and the clerk called the session back to order. There was a brief silence as everyone settled, the kind of silence that feels heavier after uncertainty has already been introduced. The judge opened the file again, not quickly, not casually, but with deliberate attention, as if confirming that what he had seen earlier had not changed during the recess. "We will continue reviewing the submitted material," he said. His tone was controlled, but there was a noticeable shift in how he approached the proceedings now, less procedural, more investigative. Emily's lawyer immediately stood. "Your Honor, we object to the introduction of documents that have not been properly disclosed during discovery," he said, voice firm but no longer dominant. The judge looked at him briefly, then back at the file in front of him. "Objection noted," he replied. "However, given the nature of what is contained here, it must be reviewed in full context before any ruling can be made." That sentence alone changed the energy in the room again. Not a ruling, not a conclusion, but acknowledgement that the material could not simply be dismissed. I remained still, observing rather than reacting, because reaction was no longer necessary. Emily shifted slightly in her seat, her fingers tightening together briefly before she forced them to relax. I could see it now, the internal struggle between maintaining control and responding to what could no longer be controlled. The judge turned another page, then paused again, longer this time. "These financial records indicate undisclosed asset movement," he said carefully, more to himself than to the room. A faint murmur passed through the audience, quickly suppressed but impossible to fully contain. Emily leaned forward. "That is being taken out of context," she said quickly, her voice sharper now, less measured. The judge raised his hand slightly, not dismissing her, but signaling for patience. "That will be determined," he said evenly. I could feel the shift becoming more visible now. Earlier, this had been framed as a straightforward dissolution of marriage, a division of property, a negotiation of terms. Now it was something else entirely. Not chaos, not confrontation, but exposure. Layer by layer, the assumptions built by one side were being tested against documentation that refused to bend. Emily glanced toward me again, and this time there was something different in her expression. Not anger, not disbelief, but calculation under pressure. "You planned for this," she said quietly, barely audible outside our immediate space. I met her gaze without raising my voice. "I prepared for accuracy," I replied. Her lips tightened slightly, as if searching for a response that would restore equilibrium, but none came immediately. The judge continued reviewing the file, and the longer he did, the more the silence in the courtroom changed shape. It was no longer passive silence. It was attentive silence, the kind that forms when people realize they are witnessing something that will alter the outcome of a system they assumed was already set. "There are additional concerns here regarding disclosure compliance," the judge stated, his tone now more formal, more deliberate. Emily's lawyer immediately attempted to respond, but the judge continued before he could fully speak. "We will address procedural matters after full review," he added, effectively closing the attempt to redirect. I could see Emily's posture shift again, not dramatically, but enough to signal that the structure she had relied on earlier was no longer holding its original form. She leaned slightly toward me without speaking, then stopped herself, choosing silence instead. That silence, however, carried more weight than anything she could have said. The judge closed the file briefly, then reopened it again, as if confirming that every page required attention. "We will adjourn briefly to allow for further examination," he announced. And in that moment, I understood that nothing about this process would return to the simplicity it had once pretended to have. The narrative had already changed direction, not through argument, but through evidence that refused to remain silent. The courtroom did not return from its brief adjournment with clarity, but with tension that had thickened further in the absence of sound. When the judge resumed his seat, there was no pretense of routine anymore. The file remained open in front of him, no longer treated as a simple submission among many, but as the center of gravity for everything that had unfolded. I sat in the same position, hands relaxed, breathing steady, observing without interruption because there was nothing left to prove in posture or presence. Emily Whitmore, however, was no longer able to maintain the same stillness. Her composure now required visible effort, her shoulders slightly tense, her gaze fixed forward in a way that suggested she was trying to anticipate rather than react. The judge adjusted the papers in front of him, then spoke with a tone that was more deliberate than before. "We have reviewed the additional documentation in detail," he said, "and there are matters that require immediate clarification from both parties." That sentence alone changed the direction of the room again, not through emotion, but through authority. Emily's lawyer stood immediately. "Your Honor, we maintain that these documents were introduced without proper procedural notice," he said again. But this time his voice carried less confidence than earlier, as if repetition could no longer reinforce certainty. The judge did not respond immediately. Instead, he looked down at the file again, turning a page slowly, then another. "Procedural concerns are noted," he said at last. "However, the content of these records raises questions that cannot be ignored within this proceeding." A faint shift moved through the courtroom, the kind of movement that happens when people realize the structure they expected is no longer functioning as designed. Emily turned slightly toward her attorney, whispering something quickly, but he did not respond with reassurance this time. Instead, he focused on the judge, as if recalibrating his approach in real time. I remained silent, because silence had become more effective than explanation. The judge continued, his voice steady but now more precise. "There are inconsistencies in the financial disclosures that require explanation from the respondent," he said, glancing toward Emily. That was the first time in the proceeding she was directly positioned not as a complainant, but as a subject of inquiry. Emily straightened immediately. "I have complied with all disclosure requirements," she said, her voice sharper now, but carrying a slight edge of urgency that had not been present before. The judge nodded once, acknowledging the statement without accepting it as resolution. "That will be evaluated in full context," he replied. The phrase was consistent, but its meaning had shifted. Evaluation implied verification, not assumption. I watched her carefully now, not with satisfaction, but with clarity. This was the point where control transitions quietly, not through confrontation, but through structure. Emily's gaze flicked briefly toward me again, and this time there was no attempt at composure in her expression. It was calculation, mixed with disbelief, as if she was trying to identify when exactly the foundation had shifted beneath her. "This is being misrepresented," she said again, but the repetition no longer carried weight in the room. The judge raised his hand slightly, not dismissing her, but guiding the process forward. "We are not making determinations yet," he said. "We are establishing accuracy." That distinction was critical, and it was understood by everyone present, even if not spoken aloud. Emily's lawyer leaned in and spoke to her briefly, his tone low and urgent. I could not hear the words, but I could see the effect. Her posture changed again, not collapsing, but adjusting downward into something more contained. The judge turned another page and paused longer this time, his expression tightening slightly as he processed another section. "These records indicate undisclosed transactions that require further examination," he said. The word undisclosed carried more weight than anything else spoken so far. It implied omission, not disagreement. Emily's hand moved slightly on the table, then stopped. It was the smallest visible sign of disruption, but in a room like this, even small signs were magnified. I did not look at her. Instead, I focused on the judge's process, because that was where the outcome was being shaped. Emily finally spoke again, her voice lower. "I did not intend for any misunderstanding," she said carefully. shifting tone from defense to explanation. The judge regarded her for a moment. Intent is not the primary concern at this stage, he replied evenly. Verification is. That statement settled across the room like a final adjustment in perspective. The courtroom was no longer engaged in argument. It was engaged in examination. An examination, unlike argument, does not require participation to proceed. I could feel the environment stabilizing into something more structured now, less emotional, more procedural, but also more decisive in its trajectory. Emily looked forward again, no longer speaking. The lawyer beside her began organizing his notes more carefully, preparing for a shift in strategy that had clearly become necessary. The judge closed the file, slowly, then placed it back down with deliberate control. We will continue this matter with full review of all financial and supporting evidence, he said. There was no reaction from the room this time, because everyone understood that the phase of speculation had ended. What remained was assessment. And assessment, once initiated at this level, does not reverse itself through assertion alone. The courtroom had shifted into a quieter rhythm, but it was no longer the kind of quiet that signaled resolution. It was the kind of quiet that follows disruption, when everyone is waiting to see what version of reality will settle after the impact. The judge sat with the file still open in front of him, no longer turning pages rapidly, but reviewing each section with deliberate attention, as if ensuring that every detail had been correctly understood before proceeding further. I remained in my seat, posture unchanged, hands resting calmly on the table, because at this stage, movement added nothing to the outcome. Emily Whitmore sat across from me, and for the first time since the beginning of the hearing, she was no longer performing confidence. Instead, she was holding stillness as a strategy, her gaze fixed forward, her expression controlled but visibly strained beneath the surface. Her lawyer leaned toward her and spoke quietly, but there was no visible reassurance in his tone anymore, only calculation and adjustment. The judge finally closed the file and set it down with measured care. At this stage, he said, his voice steady and formal, the court has identified multiple areas requiring clarification and potential correction in the submitted financial disclosures. The wording was precise, and it carried weight because it was not speculative. It was procedural acknowledgement of inconsistency. Emily's attorney stood immediately again. Your Honor, we request a continuance to address these concerns and provide supplementary documentation, he said, faster than before, as if speed could restore control. The judge regarded him for a moment, then responded evenly. The court will allow time for response, but the record will remain under active review. That sentence confirmed what the atmosphere had already begun to suggest. This was no longer a static hearing. It had become an ongoing evaluation. Emily shifted slightly in her seat, then leaned forward. This is being interpreted in a way that was not intended, she said carefully, her voice measured but no longer fully stable. The judge looked at her directly now. Intent does not override documentation, he said. The statement was simple, but final in its implication. I watched her closely now, not with emotion, but with clarity. There is a moment in proceedings like this where argument stops being effective and structure takes over. That moment had already passed. Emily's expression tightened, and for the first time, I saw something closer to realization than resistance. Not acceptance, not yet, but awareness that the framework she had expected was no longer functioning in her favor. She turned briefly toward her attorney, whispering something urgent, but he responded with a small shake of his head, signaling that immediate recovery was not possible within the current procedural state. The judge continued, his tone unchanged. Additional documentation will be required from both parties to complete verification of asset allocation and disclosure accuracy, he said. The language was neutral, but the effect was not. It placed both sides under continued scrutiny, but the origin of the discrepancy had already been identified within the file. I did not speak. There was nothing to add. The work had already been done in advance, and what was unfolding now was simply the formal recognition of it. Emily finally exhaled slowly, a controlled breath that suggested effort rather than relief. When she spoke again, her voice was quieter. So what happens now? She asked. Is this still proceeding toward final judgment today? The judge paused briefly before answering, as if ensuring precision in his response. No final determination will be made until all discrepancies are resolved, he said. That answer changed the remaining structure of the day, not because it created uncertainty, but because it established that resolution would no longer be based on assumption or presentation alone. Emily leaned back slightly in her chair, her posture now reflecting something closer to recalibration than resistance. I could see it in the way she no longer attempted to maintain earlier confidence, but instead focused on understanding the new boundaries of the situation. Her lawyer gathered his notes again, speaking quietly into a phone call as he stepped slightly away, likely initiating immediate review procedures. The judge closed the file completely this time, not as an end, but as a pause in analysis. Court is adjourned for today, he announced. The sound of the gavel was not dramatic, but final in structure. People began to move again, but the energy was different than before. There was no longer speculation about what might happen. There was only recognition that what had already been introduced would now define everything that followed. I stood slowly, collecting my materials with the same controlled pace I had maintained throughout the proceedings. Emily remained seated for a moment longer, not speaking, not moving, simply processing what had shifted beneath the surface of everything she had expected. When she finally stood, she did not look at me immediately. Instead, she adjusted her posture, regained what composure she could, and prepared to leave the courtroom under a reality that had already changed without needing to announce itself aloud. I walked out of the courtroom into a hallway that no longer felt like it belonged to the same version of the day that had begun only hours earlier. The lighting was unchanged, the architecture identical, the movement of people still orderly, but the meaning behind everything had shifted in a way that could not be reversed by routine. Emily Whitmore followed a few steps behind me, not close enough to suggest confrontation, but not far enough to suggest distance either. There was no conversation between us at first, only the sound of shoes against polished floor and the quiet exchange of looks between attorneys and court staff who now spoke in lowered voices as we passed. The sealed file was no longer in my possession, but its presence lingered in every glance directed toward us. Emily eventually slowed near the exit doors, stopping just short of the threshold where sunlight spilled in from outside. I paused as well, not turning immediately, allowing the silence to settle before anything else was said. When she finally spoke, her voice was different from earlier in the day, no longer shaped by courtroom performance or controlled defiance, but by something more restrained and uncertain. "This is not over," she said, though it sounded less like a warning and more like an attempt to stabilize herself. I turned slightly to face her, maintaining the same calm presence I had carried throughout the entire proceeding. "No," I replied evenly. "It is not over. It is just no longer based on assumptions." She looked at me for a moment, studying my expression as if searching for a shift that would confirm emotion beneath the surface. But there was none to offer. Whatever needed to be said had already been placed into the record, and whatever remained would be addressed through process rather than confrontation. Her attorney stepped closer, speaking quietly to her about next steps, timelines, and procedural options, but I could see that even he was no longer operating from a position of certainty. The structure they had entered the courtroom with had required adjustment the moment the file was reviewed. Emily finally stepped through the exit doors, and I followed a few seconds later, emerging into the exterior steps of the courthouse where the air felt noticeably different, not because of temperature, but because of distance from the enclosed tension of the hearing room. She stood near the top of the steps, looking out toward the street where vehicles passed in steady motion, unaffected by what had just taken place inside. For a brief moment, neither of us spoke. Then she turned slightly toward me again, her expression more controlled now, but with less of the earlier certainty behind it. "What do you actually want from this?" she asked, the question direct but no longer aggressive. I considered it carefully before responding, not because I lacked an answer, but because precision mattered more than reaction at this stage. "I want accuracy," I said simply. She exhaled slowly as if that answer did not match the version of conflict she had prepared for. "Accuracy," she repeated, as if testing whether that word alone could account for everything that had unfolded. I nodded once. "Everything submitted to the court should reflect what actually happened," I added. She looked away briefly toward the street again, then back at me. "You could have handled this differently," she said. I did not deny that possibility. "Perhaps," I said. but different would not have made it complete. That statement seemed to land with more weight than anything else said so far, not because it was emotional, but because it was final in structure. Emily remained still for a moment longer, then adjusted her posture slightly, as if regaining control of herself through physical alignment. "So now we wait," she said. I nodded again. "Now the court reviews everything in full context," I replied. There was no further argument from her, only a quiet acknowledgement that the process had moved beyond the point where immediate influence could be applied. Her attorney approached again, speaking briefly about documentation requests and follow-up filings. But the conversation was now procedural rather than strategic. I stepped slightly to the side, allowing them space, not because I was disengaged, but because there was nothing to interrupt. As I descended the courthouse steps, I could feel the weight of the day settling into something more structured, less chaotic, more defined by consequence than by reaction. Emily remained at the top of the steps for a moment longer, watching without speaking, before finally turning back toward the building with her attorney beside her. The separation between us was no longer emotional in that moment. It was procedural, defined not by distance, but by the direction in which the record had already begun to move. And as I reached the bottom of the steps and stepped onto the sidewalk, I understood that whatever came next would no longer be shaped by what was said in the room, but by what had already been documented and could no longer be undone. I stood on the sidewalk outside the courthouse long after Emily Whitmore and her attorney had disappeared back inside the building. The steps behind me were still active with movement, people exiting, people entering, conversations rising and falling in small fragments, but none of it felt connected to what had just taken place. The air outside was warmer than the courtroom, but it carried a different kind of weight, the kind that comes after a decision has already been set in motion but not yet completed. I looked down the street where traffic continued without interruption, vehicles passing through intersections with no awareness of the procedural shift that had just occurred a few floors above them. Everything in the city continued as normal, even when something in one enclosed room had fundamentally changed direction. I took a slow breath, not out of relief, but out of acknowledgement that the process was no longer in my hands in the same way it had been before. It had moved into review, into verification, into the part of the system that does not rely on interpretation anymore, only documentation. My phone vibrated in my pocket, breaking the silence I had settled into. I pulled it out and saw a notification from my attorney confirming receipt of the latest court status update. No dramatic language, no speculation, just confirmation that the file was now under full judicial review and additional supporting requests had been issued to both parties. I stared at the screen for a moment before locking it again. There was nothing to respond to, because everything that needed to be said had already been placed into the record. Behind me, the courthouse doors opened again, and I could hear faint movement on the steps. I did not turn immediately. I already knew who it was before I looked. Emily Whitmore stood a few feet away now, alone, her attorney no longer beside her. Her posture was different from earlier in the day, not defeated, not emotional, but reduced to something more contained, as if she had shifted from performance to endurance. She looked at me for a moment before speaking. "They are going to drag this out," she said, her voice quieter than before. I nodded once. "That is procedure," I replied. She gave a small, almost imperceptible shake of her head. "You planned every part of this," she said again, not as an accusation now, but as a conclusion she could not avoid forming. I did not respond immediately. Instead, I looked past her toward the courthouse entrance, where people continued to move in and out without awareness of the conversation taking place between us. "I did not plan the outcome," I said finally. "I ensured the information was complete." That distinction mattered, even if it did not immediately change how she felt about it. Emily crossed her arms loosely, then let them fall again, a small sign of internal conflict rather than external resistance. "What happens when the court decides?" she asked. I turned back toward her fully. "Then the record becomes the basis of the final judgment," I said. There was no emotion in the explanation, only structure. She looked away briefly, then back at me. "And you think that makes everything balanced?" she said. I considered the question carefully before answering. "I think it makes everything visible," I said. The word visible lingered between us longer than expected. Not resolved, not justified, simply exposed. Emily exhaled slowly, then looked down at the steps between us and the street below. "I did not think you were capable of this level of preparation," she said quietly. I nodded slightly. "Most people are not," I replied, "until they are placed in a situation where it becomes necessary." She did not answer immediately. Instead, she adjusted her coat, a small gesture that suggested she was re-establishing control over her presence, even if not over the situation itself. "So now we wait," she said again, repeating the phrase as if it had become the only stable concept remaining. I confirmed it with a simple nod. "Now we wait," I said. She looked at me for a final moment, her expression no longer defensive, but measured in a different way, as if she was evaluating not the argument anymore, but the structure that had produced it. Then she turned toward the courthouse steps, beginning to walk back inside. I remained where I was, watching for a moment as she disappeared through the entrance, then shifted my attention back to the street. The world outside continued without interruption, indifferent to proceedings that had already begun reshaping what would come next. And in that quiet separation between movement and consequence, I understood that the final outcome would not be decided by reaction, but by what had already been recorded, verified, and placed beyond dispute.